Good evening. For you haven't met Amy, Amy has been our legal counsel for 3 years. It's been,
Personally, I do.
they've been doing it for much longer in the industry, and we do this every year after our election to give our board members kind of an idea of what the process is, because there's a lot to it more than just voting on how much we pay for dues and that sort of stuff. So we'll let Amy get to it.
All right, so like Nick said, we've been doing this for a while now. Segan Mason and Mason is our law firm. All we do is community associations. We've been doing it for 31 years now. Bill and Bob and Donna, Segan Mason and Mason have been together since Donna was 18 and she's now over retirement age, so. Gives you some idea. I've been a partner for the last 5 years, so I've been there 20. So I do this for a living. You do not. So if at any point in this presentation, you're like, I have no idea what words are coming out of her mouth, it's a foreign language, just stop me, okay? Because you guys are volunteers, I'm supposed to know what I'm doing, you're not, right? So let's just start there and go from there, okay? So, where are you?
I think you just hit it.
I did hit it like 3 times. Did you break it?
Let me see, I'm not clicked on it. Try to get a parent meeting.
Super. Oh, it's the other one. I go down.
You good?
Yeah, now I am.
Alright.
Okay, sorry. I am technologically questionable. Okay, so the first thing to know, and some of this applies, it all applies to everybody, but some more to the board than the committee people, because committees are specific issues and they're generally not allocating money, right? So if I'm like, you have to have fiduciary duty over this money, clearly if you have no money control, you don't. But so the board members specifically, but all committee members, anybody who's volunteering in an association has a fiduciary duty to the association, and that has 3 elements: loyalty, competence, and authority. Loyalty seems like it's the easiest one, but it's actually can be really hard. Loyalty is to the association as a whole, not to your individual interests as a board member, not to the group who got you elected, not to the people who are the loudest, but to the association as a whole. And the best example of this is if every single person in the association, all 7,244 members, I think, didn't want to have an assessment anymore. You as a board cannot decide to not have an assessment, because your duty to the association is to fund its operations. That means you have to collect money from the members. So it can seem like, these people want a pickleball court and they come to every single meeting, they talk about the pickleball court, and they have the pickleball court, and we have a club, and we have, that's great. But if that doesn't make sense for the community as a whole, then that's not what you can do. So that's something to keep in mind. Second is competence. This is easier. Read your board books, read your committee packages, go drive by the violation and see what the issue is, if it's a covenants issue. Learn about whatever it is so you know what you're voting on, discussing, dealing with. And you can rely on experts. My favorite example, been doing this 20 years. I don't know what the hell fascia board is. Don't know. It's on the house, it's somewhere at the top. And people violate by not having it right. They have to paint it, they have to fix it, they have to, I don't know. But you know who does know? Covenants people. And they could draw me little pictures and they could testify in court about it, right? So sometimes you don't know, you rely on your experts, and that's perfectly fine. And third is authority. This is another one that seems easy, but it's tricky. So your authority is with declaration, the bylaws, law, right? But here's the thing, sometimes it doesn't make any sense. And that's gonna be a really hard pill to swallow when I tell you, I agree with you. I think that makes complete sense, except that's not what this says. So that's gonna be a problem, but you've gotta ask the questions and you've gotta know what your basis is when you're making decisions, okay? So you're held to a higher standard than a public official. And that goes back to the election idea. When you run for Congress, you can run for school board or whatever. Let's do school board, that's nicer. If you run for school board, you can run on the issue of, we want more summer vacation. And that's what you're going after. But if you are running for the board of an association, you are entrusted with all that money and with all those facilities, and you've got to consider that, not just what you want or what anybody else does. But as a homeowner, you can do whatever you want. So as a board member, you'd have to vote for the assessment, but as an individual homeowner, you could vote, I don't want it. It's two different things. And you'll get a copy of this later. So what's most important, your declaration? Used to be, back when your declaration was written, that they tried to write things generally, so associations could fill in the specifics, because every association is different. So some care about some stuff, some care about others. Then the courts came along and said, we want specific stuff, because when Ron buys his house, he needs to know what he can do and he can't do. Can he put up a flag? Can he paint his house purple? Those sorts of things. So what has happened is that recorded declaration, which is what established Lake Ridge, is what's most important. If it's not in there, it kind of doesn't matter. Unless your articles of incorporation, which most articles are like, hey, we're an association, we have members, we have a board, love us. It's not a lot of detail. That's second, because that's what gets recorded with the State Corporation Commission and has a whole bunch of laws that come with it, the Non-Stock Corporation Act. And then the bylaws is what says, what I like to say, what Janet does now, all the nominating committee stuff, right? How do we run? How do we do a quorum? How do we call a meeting? What's the president do? What's the vice president do? That's all in your bylaws, okay? But if there's a conflict, the declaration, yes.
So doesn't our declaration say that the board authority is whatever it says in the bylaws? Isn't there?
Yeah, it can be circular.
But, I mean, is that still legally sound?
Yeah, I mean, it can be circular, but is it? I don't know. And here's why I don't know. I don't mean to be difficult, but when there was a decision made in 2019 called Sinai versus Belmont Glen, and what that said in really brief summary was general power doesn't matter, we need specific power. But the specific power question, we don't know what that means, and that's why I'm saying we don't know. Because, for example, if your documents say we can consider color when we're looking at architectural application, does the document have to say color, or does it have to say colors of the colonial persuasion? Does it have to say shades of blue? Like, how specific does it have to be? So that circular declaration bylaws, it should be enough. Right, the declaration refers to the bylaws, and they're the bylaws. But I can see a court saying, but it's not in the declaration. So I don't really know. Here's the stupidest part of the whole thing. The reason the declaration is so paramount according to the courts is because that's what is recorded. Like any one of you, when you bought your house, went to the land records and looked up the declaration to see what it said, right? And when you get a resale package, which you all should have gotten when you bought your houses, it has all sorts of stuff in it. Like the bylaws, and the articles, and the architectural guidelines. So even if we had, it said color, and then we had a list of colors, why can't you hold people to that? But the court acted like all you have is that declaration.
Let me try
Please.
a little bit about that. So the problem that Amy's really getting at is that subsequent to the fabrication of our documents and as time has gone on, even in terms of our practices, there have been court precedents. And so the issue is not so much, do we think we can do it, or do we know we can't do it, or whatever? It's how much risk we want to take in doing it.
Excellent.
And the opinions that we generally get from legal counsel are to be conservative and not risk litigation. Because if we think the declaration says we can do it, and we do it, but somebody takes us to court to get an interpret, hoping that the court will decide we can't do it, it really doesn't matter as much how the court case comes out as it does the fact that we have to defend that litigation, and it's going to cost us a ton of money. And so what really happens is we start making judgments on what we can do with a factor of how much risk we want to take. Does that make sense? And so Amy's example about colors, for a long, long time, we interpreted, I don't even know if that's a good example, because in the declaration, but we interpreted, the declaration says that we can make rules for governing association. So we made rules, and they made some rules that aren't specifically authorized in the declaration. And then court cases across the big world of homeowner associations started associations started losing cases if it weren't explicit in the declaration, and so that has set the precedent that we are now more sensitive to not doing things that aren't explicitly stated in the covenants or the covenant declaration in order to avoid a higher risk of litigation.
These,
And in some cases, we're still doing it. We can get into this in much more detail in another forum. In a couple of cases, kind of on the edges, we're doing a couple things that are not explicitly authorized in the covenant declaration. Because we have determined through the flow of time, the board has consistently or regularly said, well, we really need to do that so bad, or we need to do it so much that we're gonna take the risk of somebody
Right.
taking us to court over it. In the meantime,
the biggest practical effect that you guys have probably heard about recently is that we can't fine people for violations. That's the biggest one. If your fascia isn't the right color, we could take you to court to get an injunction or force you to do it, but we can't actually just start putting a monetary fine. There used to be $10 a day up to 90 days where you could sit and go after somebody, and then you could put a monetary lien, so even if it didn't get fixed, at least have some teeth at the end when the house sells. That sort of thing to make sure it gets fixed. Now that's been taken away.
I think it's important to also make note with that specific example, that the Virginia Property Owners Act allows us, and had been allowing us to do $10 a day for up to 90 days, which we were acting upon. The assumption being that the Virginia Property Owners Act passed by the General Assembly should hold priority over the declarations, but the courts haven't ruled this.
Well, what the court ruled in that particular instance is the word "or." The provision in the statute says unless the association can impose fines, to the extent of the violation of the declaration or rules and regulations adopted pursuant thereto. Which up until that court case, we took as you can do a declaration or a rule. But they said rules and regulations adopted pursuant thereto referred back to the declaration, so that if you didn't have the power of the declaration, you then. It was an English problem, so. And also the problem, side note, personal, that judges don't know what HOAs are.
I was gonna say it's such a.
I didn't say that. Okay, so breaches of fiduciary duty, obviously, like, let's not steal money, that's the easy one, right? But stuff like underinsuring, inadequately bidding contracts, maintaining inadequate reserves, and this is the stuff that makes sense in your head, right? What's maintaining inadequate reserves? We have $3 million in the bank. Why do we need 3.5? I've heard that from a million board presidents, right? We have plenty of money. And then you have a snowmageddon and all of a sudden you don't have plenty of money. Or, you're a condo and your roof breaks and all of a sudden you don't have plenty of money, right? So there are reserve studies that you do every 5 years that determine how much you're supposed to reserve from a statistical perspective, that sort of thing. But these things are not as obvious as they look on this on this screen, because it doesn't look like I don't want to spend money. It looks like I want to save my association. Okay. And then this is breaching more confidences. That's a huge one. Cause you're not doing it on purpose. Your neighbor comes up to you and you're breaking your leaves and they're talking to you about some issue. And the next thing you know, you're talking about what you learned in the board meeting. Oh, but wait, that was during executive session and I shouldn't be sharing it, right? But you're trying to be helpful. You're not trying to go around and blab everybody's story. You're trying to help this person understand the issue. So again, a lot of this comes from a good place and then it just comes out. All right, conflicts of interest. All right, let me back. One of the things I did not say is I do condominium and HOA law for a living, but what I specifically do is litigation. So I'm thinking, whereas Rod's perspective and the board's perspective is a risk assessment one, right? My perspective is what's gonna happen when I'm standing in front of the judge? What do I need to have behind me that when I get there, I'm okay? And I'm assuming litigation is gonna be the end result. Is it? Okay, but that's where my brain is. So some of this stuff I will say, I'll write an opinion like, oh my God, you can't do that. And then Ron's like, it's gonna happen once, I mean, like Like, what are our chances? Okay, so that's stuff that you're considering, that's also where I'm coming from, so sometimes you might think I'm nuts, and that's why, for all sorts of reasons, but this. Okay. So conflicts of interest, again, seem really clear, right? You know, Megan's brother has a paving company. And we're gonna hire Megan's brother's paving company without bidding it, right? Let's go back to, we're gonna violate our fiduciary duty and not bid out the contracts. We're just gonna hire Megan's because we love it. And it's, oh, there's a conflict of interest because we're friends with Megan. Okay. So here's the thing, conflicts of interest can be avoided basically by telling people about them. Right? If Ron said, hey, this is my company, I'm gonna make money, and it's noted in the board minutes, and the rest of the board votes to do it anyway, it's technically fine. Let me tell you why it's not. The other big HOA case that's been decided recently is a case called Burkholder versus Palisades Park. And in that case, the lovely law firm who represents Palisades Park gave an opinion that said that the board president's inspection company could be hired by the association to do covenants inspections. Because everybody knew it was the best price, there weren't a lot of companies. So he did. And he pissed off Carrie Burkholder, who was an owner at Palisades Park. He violated her for her bird bath, which was not something she could have. And now, like 5 years later, the association is still defending a case in which they eventually lost at the Court of Appeals level. They won at trial court. And then at Court of Appeals level, the Court of Appeals said there is not explicit language in your declaration that says you can charge the members of the association for inspections. Do you know what that document says? The association has to inspect. They have the right to enter to inspect, and they can do assessments to maintain the lots in the common area and enforce the governing documents. But the Court of Appeals said the words pay for inspections was not in there. So this is gonna come up later. So this person did everything right, according to this, but pissed off one person, signed him. But also, how does it look to the community? When a board member or committee member appears to be profiting off of the association. Okay, so that's the kind of thing, like, it makes complete sense, but doesn't, right? All right, so when can you abstain, or should you abstain from a board decision? Or a committee decision? When should you not be the one voting? Obviously, if you're making money off of it, that's the easy one, right? Insufficient information. If you get appointed to the board, let's say somebody resigns, nobody here. And you get appointed to the board and that night they're voting on a landscaping contract. How can you vote on that? You don't know anything. You may have been at the meetings, but you don't have board packages, you don't have the background. So you should abstain. But you can't abstain because you don't want to be on the record as voting against or for something other people want. I have a board president who refuses to sign liens. Do you know what the job of a board president is? But he doesn't want his neighbors to be mad at him when they see his signature in the bond application. That would not be a reason to not do his job. All right, we all know we can get sued. We'll get to that. But one of the other things is, and please raise your hands, does everybody know about the Common Interest Community Ombudsman in Richmond? Ombudsman. Janet, put your hand. Okay, so about 15 years ago, the legislators in Richmond got sick of hearing from HOA people about complaints. And they created the Common Interest Community Ombudsman, who is supposed to be someone that people can complain to. Supposed to be a vehicle for this. The ombudsman is appointed by the governor and first has to submit complaints to the association. So what happens is it's kind of like a mini trial. So let's say I don't think you guys are ever meeting in the open. All your meetings are secret. I don't know when your meetings are. I can't go. I don't have minutes. I don't know what's happening. So I submit a complaint and I say, and I can do it. Can be a member of the association, it can be a member of the public. So any human being on the planet can file a complaint against the association. That's extra fun. So I submit a complaint saying your meetings aren't open. The board considers it and they're like, of course. You just don't know how to read. Writes a decision, you're a fool. Our meetings are open. For $25, I can take that to Richmond, the ombudsman, and say, this is what they said, this is what they're doing. And she has to do a whole, well, it used to be a she, has to do a whole investigation and write an opinion about whether or not we're in violation. Now, that's a crazy example. But there are associations who have ignored the decision of the ombudsman to their peril, because then they can get fined and all sorts of other fun stuff. Most people are doing things they didn't know they couldn't do. Or didn't understand that was a violation. Or in violation. And the only thing this can be based on is the law, not on your docs. So let's go back to our color example. Somebody's like, I wanna put up a pink door, and you guys deny it, and they take that to the ombudsman, like, I don't give a crap about a pink door. That's not legal, that's your documents. I don't have all the documents in Richmond of every association. All I care about is an illegal issue, which is much narrower. Okay? And insurance kicks in to defend you with. All right, now, can you be sued? Yes, of course. Why am I here? That's right. You can be sued as a board or as a committee or as an individual. Okay? The board one's easy, right? Board sued, it's not individual, it's not as scary, but it's still. But as a board member and a committee member, you are protected by the directors and officers liability insurance. And that is for the rest of your life. Even if you're sued 3 years from now, you're no longer on the committee on the board, you're still protected. Assuming you didn't do anything on purpose. The articles of incorporation specifically say that the board will indemnify you, or the association will indemnify you, unless the court finds you negligent or you've committed misconduct. Don't embezzle, that's mine. I think that's fine, that's your takeaway for the day. Okay, the declaration itself says you're protected from personal liability if you're acting in good faith without willful or intentional misconduct. So again, let's go back to that Burkholder thing, that board, they were defended by insurance because they acted with good faith. They got an opinion from their lawyer, they weren't just going off the rails, they had a whole backup for them, so they're being defended and they're being indemnified. Then the Non-Stock Corporation Act, that's one of my favorites. If you serve without compensation, you're liable for damages up to the amount you are paid. So yeah, you don't have money. And then the business judgment rule, which this is Bill Mason's favorite. Business judgment rule basically says the court isn't gonna look behind your decision if your decision is made appropriately. So if you know, let's go back to the Burkholder thing, it's a great example. Burkholder. The association considered other contracts, they decided to hire this guy as the inspection company, they had an opinion from their lawyer. They get sued for it, and the court said, look, they did everything they were supposed to do. I'm not gonna go back and reconsider that. That's not my job as a judge. I don't need to review all your contracts or look at all your decisions or look at all your backup. You guys did everything you were supposed to do, it's gonna stand. Now, do you have any questions on any of that before I go on to everybody's people? I'm talking a million miles a minute, this time I am, but you guys can stop it. Yeah.
I'm on the architectural review committee, and the issue of colors always comes up.
Yeah,
I mean, the siding, the door, the shingles. So when we, a lot of it is standard, does it match the community?
right, that's,
So we're on solid ground when we do that. For example, we have one right now.
Right.
That's coming up for the next meeting. That color for the siding is nothing like the siding in the rest of the area.
do you have standards already in place of what colors you can use?
It says very generally to match the colors of the community.
But does it-
Consistent with, it doesn't say a color,
Okay,
consistent with the area.
It does refer back in that question, I think, a little bit, because ours is slightly different, because one, our architectural committee actually stands as a separate entity outside the board, which is unique to our community. I think might have to look at it more specifically.
yeah,
Because it refers back to the builder, and I think our challenge is.
what is the builder have?
We don't have all the documentation, and we have 40 different builders that are in here, so we are kind of looking at what's here and what's looked, so. It might be a little further digging.
The non-legal opinion answer would be if it says, colors harmonious with the community and you're Old Town Alexandria community and you're all colonial colors,
Right.
then there's something to go to match it up to. The court has thrown out things like harmonious and, architectural harmony and aesthetically pleasing, because they say that's all,
Subjective.
thank you, that's exactly the right word. So, but that's why I said, do you have like a palette or whatever, but yeah,
We don't.
right.
Well, it seems like consistent with the structure type, if it's a colonial.
Well, I
or if
also
it's a
think,
brick, or
I will say this, from a court perspective, if I'm in court and somebody has painted their house neon pink.
Right.
I'm probably gonna win even without a color palette, cause that clearly doesn't match everything around it. I think where you get into trouble when it's like, it's all earth tones, or it's bright white versus a crew, or I mean, those are the things, but again, I don't wanna answer that specific
Right.
question without, but that's the thought process.
And I guess just on my time here. Just when I started last year. The age when Woodbridge, Lake Ridge was
Right.
started versus what it is today.
Right,
And I'll be honest, there've been a few times I've been sitting in there like, well, that looks pretty damn nice,
right.
but it is not consistent.
Well, I mean, we've had that happen too, I mean, like, privately amongst ourselves as attorneys, there can be beautiful things that
Yeah.
are done that aren't consistent, I mean. In Montclair, a guy installed a like slate driveway,
Yeah.
it was beautiful. And it was not even remotely allowed under the documents, so that's one of the reasons we have people apply in advance, is to make sure they don't put all that money into something and then end up in trouble.
I think one of the challenges, and you can disagree if you're wrong, that I've seen from the architecture committee is the ability to allow new things, because
Right.
of the ability, the inability to take it back if we
Yeah.
regret that decision, because it's almost like you've let it out of the bag when there's not a specific palette. We allowed it once, and so there are a lot of demands for new materials.
That's the big thing, is
Slight-
materials,
slight-
the tracks,
or
the.
The new materials, is not- and that's something that makes sense in sometimes, but then there's parts of our community that were. Because they were built with 4-foot fences, we're
Right.
afraid if we let this in. And there's a lot of people that want bigger fences, and
Right.
there's some inconsistency that I think could be helped. to
Well, and I
see
also
how
think it's
we flush
It's
that
important
out.
to remember too that. Okay. That just because somebody's house doesn't match, doesn't mean there's not a good reason, and let me say this. So let's say somebody is like, I don't remember this, there was someone who was blind. In a community, and they wanted a 6-foot fence in the backyard so she could go out in the backyard and be safe and not have to. I don't know what other protections there would have been, but they only allowed like 4-foot fences. And so they allowed that because of her specific situation, but you can see a neighbor looking at that and saying, well, he has a 6-foot fence, why can't I have a 6-foot fence? I have a husband like that, I do this for a living, I have a husband like that, okay? Well, I'm gonna take down the tree, I talked to the board member I ran into walking the dog, and he said it was okay. Oh my god, so I feel everyone's pain.
I have a question for him. Does the area look significantly different from the other homes?
Yeah, and there's a lot of areas around Lake Ridge because they're built by different builders.
Right.
No, I know, but your issue that you brought up, does that?
That comes up a
significantly
lot
look
with
different?
things like shingle color, siding color. Does it match the aesthetics of
Well,
the
it's-
neighborhood?
And that's the problem, is that becomes a subjective question, right, like.
So I think we get stuck on, well. If it was blue, then you can put blue shutters back on.
Yeah.
And that's typically how they get stuck, or if it's obvious that that community was only half blue, half black shutters, then you're only picking 2 colors. That becomes the difficulty that, and it's really expanding our options, I think, more than.
Well, kind of what I'm asking is I live in on one of those streets that has the cedar shake shingles. And one of my neighbors put up a roof that is not cedar shake,
Mhm.
and I don't personally like it. But you guys apparently approved it.
I wouldn't say we have improved
No,
anything.
just because they put it up doesn't mean anybody said okay, they could have just put it up,
Yeah, we get a lot of retroactive
Yes.
applications.
that's a big thing.
And they will deny retroactive applications if they don't apply. So people will spend money on the roof without doing it. Cedar Shake, that particular one, I do believe there isn't, Megan can talk more,
Well, I
but
mean,
there
there was-
is an alternative shingle that is allowed.
There was a process, the committee does, I mean, they kind of like this 2015, there was a neighborhood.
I remember all that.
Yeah, so they kind of took that process and applied it to the area off of Mohican. The neighbors, it was through multiple meetings.
So it did get approved, that one that
There's
does
all, well, I can't speak to the specific, but they took, the committee at the time, took the subdivisions, and I think it ended up being 3 separate subdivisions.
Yeah.
So like Cave Court is actually, even though it's in the middle of all those other homes, it's a separate, there's separate subdivisions than Fairfield Green, then Woods Cove.
Well, the point
So
is,
each of the subdivisions were kind of allowed to come to a consensus on their alternate.
well, the point
material.
is, it's not Cedar Shake. It doesn't match. I don't really think it looks that great, but it is what it is.
I mean, you can submit, submit
I
a
know.
concern and we
Nope.
can look into it.
Nope. Will not do that.
Okay.
All right, let's move on to who does what for who and how.
It's precedent though.
So first of all, this is the general power of the board. It's super fun. It's basically you have everything that isn't specifically reserved to the members. What does that mean? Okay, so the members vote y'all in, right? They vote for directors. The members would amend. There are certain things that are specifically stated what the members do. Everything else is theoretically on you. So you have some specific powers, adopting and enforcing rules of the common area, suspension in the case of a delinquency. A board member who misses 3 meetings in a row can be basically booted off. You hire him. And then you have duties like keeping records, making sure the board has to supervise Lake Ridge's team. Lake Ridge is unusual.
I'm actually at duty on the wrong side.
Are you really?
They are, the COO has to be employed or a general manager, the job title.
Yeah, but I mean, I think that they hire fire.
Yeah, oh, yes,
Yeah.
yes, that- but they do have to. have
Oh, of
to.
course, yeah. Well, that's the thing. What's unusual about Lake Ridge, most associations, most associations have management. And there are management companies out there that do little, small, big, whatever. Lake Ridge has its own people and its own staff and its own everything. So that's awesome, but it is different. And Nick has a lot more power than most managers do because it's specifically stated in the declaration. Okay, so Ron. Ron's running all the meetings. He's making sure board decisions get carried out. He's signing everything. Back to those liens, my board president, right? The vice president is backup when the board president can't act or is not around. Secretary is the one reporting the votes, keeping the minutes and resolutions, sending the notices. Of course, the secretary is not actually doing these things in a room, the computer, right? They're supervising that part of Lake Ridge's staff that takes care of that. And then treasurer, same idea. Aaron's a little bit more hands-on with money, because of course money is very, very important. But is making sure all the records and books and records are kept, running the finance committee to make sure the budget's reviewed, income and expense statements, taking care of investments. Association manager. So he's got prepare the proposed budget, spend money subject to board approval, account for what's received, prepare financial statements, appoint and discharge employees, fix compensation based on the budget limits, enter into agreements. He can do a lot. He can't, it doesn't. And then me. Okay, so what legal counsel does, other than just talking to you for an hour Tuesday night, is the easy stuff is litigation, right? That makes the most sense. I have to go to court and do that. But I'm also reviewing contracts, and not just me, it's all of us. There are 4 of us that do this. But we're reviewing contracts, we're checking, answering questions if there are issues with residents, if there are violations, whatever might come along, anything, it's like I'm general counsel at IBM, right? Like I handle whatever comes through the. But I only represent, we're back at the beginning over here, when we were talking about the association as a whole. That's who I represent. Not Ron, not Nick. I represent the association as a whole. So sometimes I'm gonna give opinions that I don't like what y'all are doing. Because I have to represent the association as a whole, not what the board's doing, what the individual owners are doing. Now, sometimes that looks to the outside like I'm representing the board. The board's made a decision and I'm supporting it, but that's because I'm supporting the board doing something based on the governing documents, right? It's not just because I like Nick and I like Ron. That can be difficult because you're all gonna want to talk to me. And you can't. Nick can talk to me, or Ron can talk. And Ron's policy has always been, if the board members have questions, they need to go to Ron, and Ron will decide what comes up to me. Because if everybody calls me, your bill is gonna be ginormous. And it can end up with internal fights sometimes. Because different people have different opinions and they can ask me questions differently. It's like having kids. And I mean that nice, right? Your kid comes to you and says, can I have chocolate milk? Well, sure. I didn't know you had 4 chocolate milks already. So now you're having your 5th. That's a problem. Then if it all goes through Ron, he could say, okay, here are all these sides. This is what we're going to do. Okay? So the architectural committee, like Nick said, is its own separate thing. That's common in and of itself, that the architectural committee is defined in documents, but it's very independent here. You see their members, their alternates, they do certain things, they make the rules. And this approve and disapprove an application within 30 days, that's cool. Somebody makes an application and they don't act within 30 days, it's assumed to be approved. And then the board can appoint other committees. There's a nominating committee, we all know about that. There's a finance committee, apparently now there's an ecological committee,
Ecos. Yeah, it's a long name.
Urban forest.
Conservation.
Urban forest, there you go, that one. So, all those can be created by the board appoints those people, and then the committees do what the board tells them to do. The committees are not spending money, they are not making decisions. Everything has to come back to the board, except for that architectural review committee. Everything has to come back to the board first. So board meeting rules, these are my favorites. Must all board and committee meetings be open to owners? Yes. There are no follow-up questions. Whatever scenario you're thinking of, the answer is yes. Hey, we're the covenants committee, and we're walking around the neighborhood looking for violations. We know the owners. We're just talking about stuff. We're just talking about what colors we might paint the community center. Open to all. Must we take minutes of all the meetings? So yes and no. This becomes kind of a circular thing. You have to take minutes of all open board meetings. You don't take minutes of executive session meetings, which we'll get into what that exactly means. Generally because no actions are taken in them, so there's nothing to write in your minutes. But what's the no? Well, committee meetings are weird. Because if you are the social committee and you're trying to decide about the Easter egg hunt, do we really need minutes of what we're talking about? We're deciding, and then whoever's running the committee goes to the board and says, here's what we want to do for the Easter egg hunt. And they report back. You don't necessarily need minutes, but when you're the finance committee, you might need minutes. So it's kind of, I think the practice is, Neil's done his 4 million deer management thing, or trail things, right? So he's reporting back, he's not submitting minutes. That's okay. But you are sharing that information with the board because the board is the ultimate decision maker. What if an owner wants to record a meeting? This one's a little inaccurate. Not so much here, but general. It used to be, and this has happened, people would show up with little recorders and microphones and put them in front of you. So boards would come up with rules about how far away the mics had to be and who could record and how many recording devices there could be. Now in today's day and age, just suckers on Zoom, they hit record. What's important? It's good to know if anybody else is recording it. I think it's a good practice at the beginning of meetings to say, hey, is anybody recording this meeting? So you know. Bill Mason, our firm used to represent Ruston Association. He used to do all the covenants work for them. And those meetings were recorded, and I hear through the grapevine, show it parties. I don't know why, but it happened. So yes, people can record these and show at parties. They can post them on YouTube. It's insane, and I don't know why anybody would want to, but it happens. But they're allowed to record it. Theirs is not the official version. What is the official? Does anybody know what the official version of the meeting is?
Approved.
Exactly answer.
Sorry.
Right, approved minutes. Thank you. It's like Janet answering. Like I keep people going. All right, must we have an owner's forum? Yes, at all board meetings. So you guys have one at the beginning and one at the end. I actually kind of really like that. Because the point of the owner's forum is for people to comment on what they care about for the association. Comment. Not get answers, not get into a discussion. Ron does a great job of it. He lets people talk and he goes, thank you so much. Now, when would you answer an owner? My trash is never getting picked up. Keep putting it out on Monday, it never gets picked up. Ron could be like, actually trash day is Tuesday. Be your problem. right? Factual information you can share, but don't get into a discussion, don't have a whole that's not what it's for. Why? 2 reasons. One, the board is a group and has to make decisions as a group, so any board member answering technically is not correct. Even if it's the board president. And 2, that's not what it's for. It's for people to communicate to the board their concerns. If it's a special meeting, like if you just have a meeting about the budget, then comments can only be about the budget and you can make reasonable rules. If 20 people show up, you can say, okay, everybody sign on this piece of paper, everybody gets 2 minutes, you only get to be heard once. You don't need owners' forums at committee meetings. Must executive sessions be noticed and posted? Yes, they're part of meetings. You have to be in a meeting to have an executive session. Work session is a meeting, everything's a meeting.
Question.
Yes.
I just wanted, it's a general question, just in case.
Yeah.
Well, what constitutes a meeting, like,
Oh, that's fun.
are you, is that?
Okay, so what constitutes a meeting? I'm gonna ask you. If you and Ron and Aaron and how many board members do we have? 9. I'm not gonna be able to name anybody else out my head. If there are 5 board members at Starbucks in line in the morning to pick up coffee,
Meeting, yeah,
is that a meeting?
cause we have one, yeah.
No. it's
Really?
not.
Well, it depends on what we're talking
It
about.
depends on what you're talking about, exactly. If you're all if every one of you is present at the high school basketball game, because all your kids are on the basketball team, that's not a meeting. You're not discussing the business of the association. If you're discussing the business of the association, then when it kicks in. But again, let's talk about appearance. If you're all at Starbucks at the same table, that's not gonna look too good, right? But if you're all just in line, that's a different thing. So that's what constitutes a meeting, basically. You know, short.
And that can be in person or like online discussion too, right? Okay.
We'll talk a little bit about discussing too later. So- Okay, when can we meet in executive session? Okay, remember how I told you at the beginning that if you ask me the question, the answer is yes, the meeting has to be open. This is when you can't have an open meeting to discuss personnel matters. Nick is not a citizen. ICE is coming to take him. That's a personnel matter. We're gonna discuss that in executive session. To consult with legal counsel. Discuss and consider contracts when stuff's pending, or you're trying to decide about a new landscaper, you don't like your landscaper, those sorts of things, okay? I should probably say pool company for you, shouldn't I? Pool. Discuss and consider pending or probable litigation. That one's a little fuzzier, because what's probable litigation? If somebody just says they're gonna sue you, is that probable litigation? Depends on the person, we can make that, have that conversation. Discuss and consider rules violations, don't paint your door pink. Discuss and consider personal liability of owners to the association, that's called delinquency. Right, it's also called destroying property, we've had that happen too. Not me either. Alright, can we make decisions outside of meetings? Generally, yes, if you all agree. Not Ron's on vacation in Tahiti and he can't answer, but everybody else agreed. We all have to agree. And you only want to do it when you absolutely have to, because remember how all meetings are open? And how we look to the community? So we only want to do that when we absolutely have to. Lack of transparency is that, yeah, if I had a nickel for every complaint to the ombudsman about people not having open meetings, I wouldn't have to have this job. If I had a nickel for every time that they were right, I would be poor, because it's almost never true. Can I talk to or email board members or committee members about issues between meetings? Okay, this is where it gets fun. A lot of the court decisions on this are about FOIA in like school board meetings and city council meetings and stuff like that. But basically, if I'm emailing and I'm saying, hey, here's a picture of that violation we talked about tonight. That's fine. I just sent you information. Here's a copy of the report. But if I say, hey, here's a copy of this, I don't think this is a violation. You email back. I think it's a violation. Here's one. Let's talk about Ron. Ron comes, he's just, now we're having a whole conversation and that becomes not a meeting, because it's not quorum, but inappropriate, right? This used to be, again, how fast technology is changing. It used to be this was an email question. Now it's a text question, right? We could text each other and think how fast that'll go. Also, I don't ever want to deal with discovery of text messages. So please God, don't text. Just, I don't need that. And if you do use whole words and not abbreviations, I don't want any of those meetings. Okay, so yes, you can, but you really shouldn't, is the upshot. Virtual meetings and voting, okay. This is actually, it used to be, yay, we could do virtual meetings, right? We don't all have to be in the same room. It used to be you had to have 2 people in the room in order to have a meeting. Also virtual, that got eliminated around COVID, so now you could be all virtual. What I've seen coming up now, which is interesting, is that people are flipping it around and saying it's an accessibility issue. People are complaining that we want it on Zoom because we can't get there. Because I'm a mom and I can't leave my kids at night, or I'm partially deaf and I can't hear very well, or whatever. And they're trying to force meetings to become virtual. Now, for a place like this, you guys can do it like this. Smaller associations don't necessarily have the technology to do that all the time. And what's important to remember is that the default is a meeting is in person. 10 years ago, 20 years ago, there wasn't another option. You showed up or you didn't attend the meeting, and that was okay. There are accommodations if you are deaf and attending the meeting, right? We can hire interpreters and stuff like that. But if you just want it virtual, you don't have a right to virtual. And it's a board decision or a committee decision. I'm not saying you shouldn't have access, that's not, but I'm just saying from a required perspective. All right, now we're gonna talk about collections. Let me tell you what's so important about collections. If you don't collect your money, you do not have an association. Right? Now, most of the collections work for losing that little c is done at Nick's level. They send notices, they send reminders, they impose a late fee, and then hey, and then people pay, right? That's mostly what happens. But if that doesn't happen, it comes to me, not me personally. Actually me personally. So what happens is we have certain legal requirements that can make it look like we're not doing anything, and we actually are. It's like watching water boil, okay? So when it gets to me, I'm required by federal law to send a letter that says, hey, Lake Ridge says you owe $100. You have 35 days, and it's 30 regular days and then 5 business days. So if I send a letter today, it's April 30th is the due date. Think about that. You have 35 days to pay. If you don't, we're gonna sue you and we're gonna file a lien against your house. Then that 35 days goes by, they haven't paid. So then we prepare an affidavit of claim, which is just Ron signs off or Nick signs that, right? You signed that?
One of them, yes, I said that one.
You said that. And it says, this is really what's due. We check a ledger. This is really what's due. Not in the military, or I am in the military, whichever one it is. And then we file a lawsuit. We have to give 6 weeks for the sheriff to serve that lawsuit, or 8 weeks if we're suing it through the Secretary of the Commonwealth or somebody who's outside Virginia. We also file a lien at that point. Ron has to sign the lien. And that just gets filed in the records. That doesn't require any downtime. And then once we get to court, we can take judgment, and then we can garnish people's wages, their bank accounts to try to get paid. Sounds so simple. It so isn't, right? Because how many different things can happen? They call us, they don't understand the charges. Somebody got messed up and their name was spelled wrong, it was posted to the wrong account. We can't find them for service, they file bankruptcy, they get foreclosed on. I mean, there's a million different things that can happen. So that can all kind of slow down the process. Our goal is to get the association secured, which is the judgment and the lien. Because then you have extra protections, because that attaches to the house. And then if you sell, refinance, anything like that, we get paid. It's a red flag. Okay, our goal is to get you paid, but. Does that all sort of make sense in my super fast way? Okay, bankruptcy stuff. Here, don't ignore chapter 11. Chapter 7 is you don't owe it anymore, you're free. As for people who are just really on the skids. The liens would remain, but they no longer owe that money personally as of the date of filing backwards. So we can't garnish, we can't get a payment plan, we can't do any of that. In a 13, that's a forced payment. So they have 5 years to pay off all the amounts due to us through the date of the bankruptcy. And it usually takes that long. In both cases, the people still own the property, they still owe us money. So it doesn't forgive anything going forward. They still owe that. It's only backwards. My favorite are chapter 13s because people pay us. Now, that was a lot of information, super fast. Any questions, Ron, is there anything you want me to talk about more?
Entertain questions.
Just out of curiosity, how often does that happen?
Bankruptcy?
Yeah. In associate, in a, something like this.
Monthly, we've got one or two that gets flagged. In terms of delinquencies, cause we're collecting a $2 million a quarter plus, so I mean, it's a large budget that we collect from everybody. We've got outstanding, and this isn't just 1 year, this is over the multiple years. And it really only comes about 2% or between 2 and 5%, but it's about $250,000 that's outstanding delinquent. That's, and a good bit of that is secure. And that's kind of where it is. We're pretty, if somebody hits those marks, there's no question, they're going to court. We're going to secure that lien before all else. Right now, in some cases, that even means spending more than what's owed. Because unfortunately, not unfortunately, but due dues are pretty reasonable, so it can take a long time to owe enough to make it worth the squeeze, but if they sell. Or foreclosed on for other financial reasons, you have trouble ever getting that money back. So we will go after anybody the second it is, and then.
It's also a principle thing, I mean,
Yes.
honestly, if you don't do it, people learn that they can wait
Yeah,
longer.
we're without the whole community.
It's a nonprofit business, it's a cost of doing business is the collections, every business that has income is gonna have collections of some sort.
Yeah, that's true. Yes, Steve.
I have a question, to what degree does fair housing impact or not impact the board or whatever we're doing? Like, should we be concerned about how that influences our roles?
Well, there are two different things. There's, if someone makes a fair housing claim or a fair housing request, that's one thing, and then we address it. So if somebody makes an accommodation, and typically you don't see that in terms of boards, you see that in terms of access to the pool, that sort of thing. Because it's fair housing requires that people who are in a certain list of categories get equal access to things. As if they were not in that category, I guess is the best way to put it. But in terms of the board, you don't need to be concerned about fair housing unless it comes up, honestly. Again, this is like, I mean, I kept making the joke about embezzle, like, don't discriminate against people. So don't expect handicapped people to walk upstairs. Like, I mean, some of it's really practical and common sense, and you guys have so much access here. I mean, you've got.
So
grants.
one of the things I think gets confused in that question too is also the ADA.
ADA is not.
It doesn't, except for it does for us a little bit, because we allow the public into our pool, into some of our outside things.
Right.
So in those cases, our rec does have to do it. So in most cases, ADA wouldn't apply to association. That's apartments. Those are commercial places, but since we do allow the general public into some of our rec things, like you can sign up to do any of our baseball.
Right.
We do have some ADA considerations that we have to be aware of when we're planning events.
But that's as far as it goes.
That's as far as it goes. Otherwise, it would be accommodations, and in that case, we probably are obligated, it'd be the ARC. That would be the,
Right.
I need an approval for a handicap ramp. And then they would have to pay for that handicap ramp. They're paying for their own accommodations through that. But we probably wouldn't be able to say no, but we could put reasonable limitations on how long it's there. If you sell the home, you have to remove it. There's certain things like that you can.
The other thing about accommodations is that it's a little harder here because you guys are so big, but they have to be financially reasonable and not change the nature of the association. For example, I have a community that has an elevator, and there's a gentleman who's been hospitalized and he has to go up and down stairs now, and that's a problem. And the family wanted us to hire someone to, basically a medical company, to take him up and downstairs anytime he wanted, and like, so that he had access to his unit. and have somebody there to, there's like all these things about like having medical personnel there. Well, that's not what an association does. That's not what they're there for. They don't do medical transport. And the financial obligation was such for this community that it would have been exorbitant. So like, those considerations do come in. Something like allowing a ramp, no, because the person's paid for that themselves, and you know. But if you were installing a ramp for the pool,
Yeah.
that can be something that we would have to do, not that, so.
Thank you very much.
Of course. You know. Make it?
One thing I don't think we kind of might be helpful to kind of talk about too is everybody's role between the committees to the board. I think we have a new committee, that's one that's great to see more new committees. That's really how we get a lot of stuff done is the committee and volunteer work. That's the hardest thing to get started here. But the board is going to be setting policy. They're not running the association. They have hired all of us, or in other cases, a management company or somebody else to do the day-to-day business that they're paying for somebody to do it. And unless you're in a really tiny association, there's always somebody that's in the background doing something on it. And so their whole job is to set the policy and the direction and kind of point us where they want us to go. Your job as the committee is then to find those specialty areas, because the 9 members of the board aren't all looking at covenants, aren't all looking at finance and the money in the same detail, or the trees and what we need to do with our 4,000 acres of common space and from a ecological standpoint. So the board is going to set up its committees because they think the issue is important and they want other volunteers and community members to then come to them with policy and direction that can be as simple as, these are the 5 projects we want to find volunteers to do throughout the committee. This is what it'll take to advertise. This is the staff resources we'll need. And in some cases, this is the budget we need in order to get those sorts of things done. That's what the committee's really gonna do, and then run those special interest corners of the community. And as we get more special interests or more things, you set up another committee that would either be ongoing, like the Trails Committee has been going on, because that's been an interest for so long. As long as we have the volunteers, I expect the Eco Committee or some sort of biodiversity committee of some sort will stay, because that's normally one that's lasting in associations on the ones that we have. And so you're always gonna be looking at, okay, these are the policies, or these are the projects we wanna get done. How do we get the board to approve them, to then fund them, to then allow them to continue to go and not just be one-off projects? Sometimes you do have an ad hoc committee for one real special thing where we're just gonna do, say if we were going to redesign all of our clubhouses to have a certain aesthetic, you could get a community set up a committee up that only exists for that one project. So, or we have a capital improvement fund that the board has started, and we don't have a whole lot of direction at the moment from it. The committees would be a great place to get direction for those projects or ideas. Or to review projects or ideas that the community presents in that sort of sense, and then direct to the board, and the board directs us how to implement them, and we find the ways to get it implemented. So it's one thing to perspective, some board and some homeowners come in, and especially homeowners come in sometimes and say, we just want it done, why can't you just change the rule?
Right.
And it's never that easy. It's always a much bigger ship to steer than just changing a rule that quickly. So it really does flow up and then back to us. And if we're doing the work, you guys normally don't get in trouble when something goes wrong.
Anything else?
Lots of pizza. People will take some pizza back.
All right, thank you, Amy.
Of course.
Won't take any more of your time. Thank you all very much for giving us this time, and thanks for the presentation.
No problem.
And this is not the end of the time, but you can, I mean, you don't forever not. You can keep asking questions, that's the same way to say it. Just because you didn't think of it tonight or whatever, feel free to funnel them in, a lot of things, it's efficient to, use a general manager as a focal point or as a, convergence, point. But you're also free to, send something to me. So between the two of us, we will, track things and, as Amy's example was, sometimes, one of the reasons we wanna do that is because if one person has a question, it's quite probable that somebody else has the same question. And we wanna be efficient in answering it, for all people. And questions that come in, we will answer for everybody, not just for the person who asked it necessarily.
I would not ask that anybody, because I don't assume that I'm going to agree with your opinions in this community. Or everybody's opinion, you're not gonna agree with mine. But I do ask that you try to at least be re-educated on the issue. So there could have been, this 50 years, there's probably gonna be some decision that was made that you don't agree with, and then maybe even or probably even I don't agree with in the past, that stands that we're stuck with. There's probably some specifics of why we're stuck with them, and then realities that we've got to deal with, so being reasonable in that, and I will be reasonable to find any out of the box way to get around those problems if we find them. That's all I would ask, is you look for the answers and allow us to find them for you. We had some angry people in this week's collections and covenants time, so just putting that out there as well.
Okay?
That's the only.